Welcome to our session on spatial computing and privacy in the age of AI. Not special, spatial. We have quite a bit of time today and an excellent panel, so we hope to get a real deep dive into some of the issues that and challenges that spatial or advanced wearable devices pose, especially those powered by AI. We are talking about items that are packed with sensors, motion recognition, iris motion detection, so uses and applications that bring back questions not only of personal data processing and protection and informational privacy, but also very much physical privacy. And so we will be discussing this with excellent speakers. First of all, to my left, we have Professor Brent Mittelstadt, who is an associate professor and director of research at the Oxford Internet Institute, University of Oxford. He leads the Governance of Emerging Technologies research program, which works across ethics, law, and emerging technologies, including AI, which is no longer very emerging, as we all know. We also have Professor, Silvia De Conca who is assistant professor of law and technology at the Vrije Universiteit in Amsterdam. She co-chairs the Human Rights in the Digital Age working group of the Dutch Network for Human Rights Research, and she's also part of the Network Institute, a multidisciplinary initiative of the Free University of Amsterdam, fostering research in the digital society. And she works also on the privacy implications of smart homes and the Internet of Things in general. And finally, we have with us Eric Neutschwander, who is Apple's Director of User Privacy in charge of privacy engineering efforts across Apple's different products and services. And his team works on privacy by default, including data minimization, technical limits of data uses, applications of data protection, on-device processes, and he will be able to enlighten us about some of the practical solutions for the challenges that are posed by spatial computing. So with that, as I said, we have quite a bit of time. We will start with a first round of opening statements. We will have some slides from Brent. And throughout, I will also give you already the possibility to ask questions. So we will not wait for that until the end of the discussion. There will be a mic circulating somewhere. So, if you want to ask a question, just give me a sign. And also state your name and affiliation if possible. And we hope to also reserve some time at the end for more questions. So with that, I would give the floor to Silvia first to talk us through some of the more obvious or less obvious challenges that society faces because of the developments in AI and spatial computing.
Thank you. And also thank you for having me on this panel. I'm very excited actually to talk about this. I'm sure everyone roughly knows that obviously there are problems with the massive data collection that comes with the devices that enable spatial computing. But I think we need to dissect a little bit the different implications before then we delve also in looking at some solutions, technological solutions, which are very promising, and also on bigger risks. I think that the data protection aspects of spatial computing might, in the immediate future, catch the attention of regulators and practitioners and academics a bit more than the more privacy aspects, because in the European legal system, we do separate to a certain extent the two. And I think it's important instead to look at them a bit separately. So if we consider the people that are involved in spatial computing, we obviously have the users of these devices, possible bystanders, or people living with the users, and we have the service providers. Now, if we think about the privacy implications, setting aside for a moment the personal data, the mere presence of devices that might be recording and analyzing the environment around the user can have consequences on the bystander's privacy, on the people living or working around them. And obviously, of course, the data will be collected in some cases, also of the bystanders, but the mere presence can create things like a chilling effect. Whether it is in the home, in an office, or in the streets, we might have people simply having a mismatch with what they expect their level of privacy should be when they notice these devices, when they notice that the spatial computing is happening around them. It can make people uncomfortable. It can affect their freedom of association, their freedom of expression. They might decide to behave differently, which is, the definition of the chilling effect. And that doesn't even need the data collection or the personal data of the person being collected. This is the mere presence. We have registered this over and over with other technologies. And I think it needs to still be acknowledged. This can be very disruptive in a more intimate setting, like a home, but it can also be disruptive in public, because we need to remember we do have privacy expectations in public. We expect that people might see us. We don't expect to be recorded. We don't expect that data to be further processed. And most importantly, anonymity is key to maintain our privacy in public settings. And some of the wearables that can enable spatial computing might clash a bit with that. Then if we look at the user, obviously there's going to be collection of data on the user, and their own privacy of their own actions and their behaviors can also be affected. And that can create occasions for surveillance, corporate surveillance, but also state surveillance. Because there is actually a beautiful report from the intelligence agencies in the US that clearly shows how they buy commercially available information. So we need to protect users also, even though the users are the one that chose to enjoy spatial VR or AR and other forms of spatial computing. We need to have excellent safeguards in place, whether it's a video game enjoyed at home, or glasses wore at a party, or any other device were in public. We need to make sure that the access and the use from the companies and the state is adequately regulated. And if I may say the last, just a couple of concluding remarks. In this sense, for developers, we have a very hard job, in my opinion, because one of the things that we cannot do is separate the functionality from the very occasion for these types of surveillance to happen. Because we need the data, we need to analyze the space around the user, we need all of those information and the devices to enable spatial computing. So at that point, the technical solutions become fundamental. And I realize it's a big challenge to, for example, try and develop in the coming decade technologies that works with less data maybe, or that new forms of encryption and anonymization, etc. But also we need the legislator to understand that there is a big risk of over-inclusiveness. If we apply certain regulations strictly, we lose functionality. We might even lose the products. And users want this product. I myself enjoy very much VR gaming, so it's something that we want to preserve. And the legislator also needs to lead by example. Many member states are really enthusiastically accessing digital information, data from other services. As I said, the intelligence agencies are buying them as commercially available information, or there have been case law on trying to access information even from wearables or Internet of Things. So the legislator also needs to start leading by example and understanding that just because it's available doesn't mean that it needs to be used, and we don't know how efficient this form of digital surveillance is. And in order to actually have an enjoyable product and get back that promise that I had when I was a teenager in the 90s of what the internet would be, we also need to start less of these predatory behaviors from both private and public entities that I think would give back really some trust in the users in that sense. So that would be it. Thank you.
Thank you very much for this introduction. One remark that comes to my mind is that indeed, even though also in this venue we are used to discussing the GDPR, data protection and data processing and related guarantees, I think here what you are saying, we are more firmly in the sphere of privacy, including as it was very traditionally understood from the very early days from Warren and Brandeis and Alan Weston and which obviously, like you say, is often linked inextricably to processing of personal data, but not necessarily the same thing. And in the EU, we even have a separate fundamental right for each of those. So maybe we can also have a discussion about that later on. But before that, we will move to Brent and your presentation.
Well, thank you. Thank you so much for inviting me to the panel. And just some remarks while we get my slides loaded up. So basically, I've been working in the space of ethics, of computing, data ethics for about 10 to 15 years now. I won't say exactly how long so as to not date myself too bad. And I think there's a lot of prior technologies that we can learn a lot from in terms of their privacy risks that tell us about the sort of things that we'll encounter when it comes to spatial computing. So I just want to briefly look at some examples of, of prior technologies that have raised privacy concerns, and then look at one particular problem that I think is very relevant to AI, but that spatial computing creates sort of new opportunities, new risks, and that's around how we can draw inferences about people from the data that we collect from them. So just to start with a couple of examples, again, of prior technologies where I think either the privacy risks of these are inherited by spatial computing. Some of these you might consider to be spatial computing directly, depending on how you define it, or the privacy risks end up being changed in some way by them. So I started out actually working on wearable devices, the ethics of wearable devices, health monitors. So these could have been things that were used, say, for elderly care, dementia care, things like detecting if somebody has a fall in their own house, all the way through to wearable devices that were, say, blood pressure monitors, glucose monitors, that sort of thing. And this was even before Fitbit and before the Apple Watch, so this was very early days of this. And we know that there are sort of very significant privacy concerns with the sort of data that is collected by these sorts of devices, what they can reveal about your health, both explicit things, things that they're collecting, say activity levels, sleep quality, that sort of thing, but also other things that you can infer from that data. Another example, another technology where I think we're inheriting the privacy risks would be, in this case it would be Roomba, but it would basically be any technology that maps physical spaces. There are many technologies that do this now. And the reason that this is really interesting, I think, is because, for one, there's the physical privacy aspect, which Sylvia mentioned, which I fully agree with, because it's not just about the privacy of the user, it's about the privacy of anybody that they share the space with, be it members of their family, flatmates, or indeed if you're using it in an enterprise context, coworkers, anybody that's in the same space as them. But you can actually infer quite a bit from data that seems relatively benign. So yes, Roomba needs to map your house, map your rooms in order to do a good job of cleaning them, but you can also infer a lot from the data that it collects. If you know the size of somebody's house or the size of different rooms within somebody's house and you know the location of that house or rough location, you can infer very accurately what their socioeconomic status is. If you are able to detect objects that are on, say, the floor of the house, if you're able to detect toys, for example, you have a pretty strong signal that this person either has childcare duties or has children themselves. And so suddenly you're inferring things that would be considered very sensitive about a person's life from something that seems extremely benign from the outset. This is a much older example. This is a 9-year-old article at this point when there was the big scandal over voice recording by smart TVs, which has since been dealt with in a variety of ways. But this is, I think, what I want to point out here is actually the chilling effect that you mentioned, Sylvia. I completely agree with that. We saw that even in the early days of health monitors, where just the presence of an environmental sensor in the house could have a real chilling effect or real change on behavior of the person or people in the house, leading them in. I interviewed some people that had these sorts of sensors. In some cases, going so far as to they wouldn't enter the room that the sensor was in, or they would spend very little time in the room that the sensor was in because they were worried, rightly or wrongly, about what the sensor was actually looking at. This is both a new example and a very old example. I think we have to remember we're inheriting the sorts of privacy risks that come with any sort of video or audio recording technology. In this case, we're talking about Meta and Ray-Ban and the smart glasses they have, where essentially you can record video and audio very easily. Of course, these have AI built into them now, because what device doesn't have AI built into it now? But yeah, just a reminder that these are very basic, well-established, long-standing privacy risks that are also being inherited here. There's also a question here, I think, of physical and social privacy, and that has to do with sort of the governance and privacy in virtual spaces. So this would be, for example, access to a physical space, say in a like virtual chat room app that you would have, VR chat, for example. It would be about the ability as a user to set privacy preferences, who can see your avatar, the name of your avatar, who can hear your voice, whose voice can you hear, these sorts of things. And a lot of that has to do with combating harassment in virtual spaces. And then the last example I'll give here, and this leads us into inferences, is about the sort of what can be called biomechanical data that's collected by VR headsets. So this is behavioral data, both sort of the apps that you are using, but then also motion data, so what you're actually doing while you're using the app. And there was some really good research. This article is about some research from researchers at UC Berkeley that were showing that just using biomechanical data, in this case collected from users of a game called Beat Saber, that you could actually infer very reliably very sensitive things about those users. You can infer their age, you can infer their health status, disability status. They claimed you can infer marital status. There's a whole list of things that you would think, oh, you couldn't possibly infer that from somebody's motion data, but actually they showed with their model that you could. And I think they made a really useful comparison in their work where essentially they said biomechanical data collected by these headsets is essentially a new form of biometrics. It's as reliable as facial recognition, as reliable as a fingerprint in uniquely identifying people as they move across different apps or app spaces. And so I think that is, to me at least, how I'm treating that sort of data going forward, is that the signals it provides are as uniquely identifiable as these other things that we're used to. So the last thing that I just want to talk about is that problem of inferring things about users. I did some work with my colleague Sandra Wachter, I think 5 years ago now, looking at how data protection law protects against inferences, basically drawing sensitive or invasive inferences about people from data they've either provided or you've observed. And again, this could be very, very benign seeming data that you are able to infer very sensitive things from. So just as a simple example of that, if you saw this photo posted on somebody's Facebook profile, how much could you actually infer about them from this photo? The inference doesn't necessarily need to be reliable, but what sort of best guesses could you actually make about the person from this photo? You could try to infer marital status, ethnicity, socioeconomic status. You could infer something about gender. You can infer a lot from it, and again, rightly or wrongly, it sort of doesn't matter. It's more about your willingness to infer those sorts of things and then do something with that information once you have it. So that's essentially the problem that we're dealing with now, is that we're creating more and more data passively. It's not about us sort of intentionally creating data. It's about using devices and apps that collect lots of data, and it's sort of unavoidable because they're core to the functionality of the devices. So we have more data. We also have more ability to make sense of that data, to draw inferences from it, to learn things about people from that data, and to do so in ways that are very inaccessible and very inexplicable to the people, the users that are involved. And then finally, that data and what we learned from it sticks around. It doesn't get forgotten. Machines don't forget in the same way that we do. It's very easy to share that across apps, to share that across different spaces, and whether users are actually aware that that is happening is a very important and very, I think, under-examined question. There's also the question of whether the things that we're collecting, whether these inferences are actually sufficiently protected by the law. So in that piece of work, we looked at data protection law, and we looked at the status of inferences in data protection law, and in particular, what you would have to do in order for something to be counted as a, quote, sensitive inference. So something, again, about health status, gender, religion, political affiliation, that sort of thing. And there's been a lot of case law on this since we published the paper that was looking at primarily whether you had to intentionally draw an inference about somebody's, say, health in order for it to count as an inference, and whether your method had to be reliable. And the intention question hasn't been examined directly so much in the case law, but what we have seen, and I think quite rightly, is that it doesn't need to be reliable in order to count as an inference. If I choose to infer your political affiliation and I get your political affiliation wrong, it doesn't matter that I got it wrong. It doesn't matter that the method I used, the data I used wasn't reliable. It still counts as an inference, as a sensitive data, and therefore needs to be protected. And the last problem, and something I'd love to talk about more, was raised by my colleague Sandra Wachter in a wonderful paper. If you read any paper about non-discrimination law and AI, make it this one, because it's really, really important. And this is about how the sorts of groups that we can create with AI, these groups that are assembled from inferences, how they essentially fall between the cracks, how they end up not being the sorts of groups that are actually protected, in this case by non-discrimination law, but also data protection law. And a very sort of simple example of what that looks like, why this is such a problem. If we have a set of features that we inferred, and we can assemble some groups or some audiences or some sort of collective that we find useful for whatever reason, it may be that that collective makes absolutely no sense, that the people that this data is about have no idea what group they are a part of. But also, depending on what we're looking at, the groups can change over time and change very, very quickly and may not exist for very long. So the question is, if you're discriminating against a group like that, if you're violating the privacy of a group like that, how do you actually protect them if they don't know and if they can't do anything about it? So I'll end there, but thanks so much.
Thank you very much. I propose we go now to our third speaker and then open for first round of questions. So, Eric, what struck me in both presentations is, of course, not just the sheer scale and number of potential challenges, if not harms, but also the claim that many of those are unavoidable if we want to preserve functionality of those devices. So, what's your take on that?
Oh, thank you, Anna, and I'm really pleased to be here. Thank you all for coming. I suppose I will talk about the risks and harms, but I start from a fundamentally optimistic position that actually we can develop technologies that will solve this. I think there are some real great things that can be done for users, and we just need to be mindful of the risks up front in the design, and that's the best way we're going to minimize them. I mean, certainly, even when I think back to when we were developing Apple Watch or getting into the health space, what was intriguing to me is that we didn't question our approach to privacy at that time. And it was only with the growth of AI recently and with spatial computing that even inside of Apple, some people started to say, well, this technology is so novel, it's so different, that maybe we're going to need to change our approach to privacy. You know, will it be the case that actually the rights people need to have are different or need to be expressed differently? I don't think that's true at all. There was a lot of concern about, well, there are going to be novel threats, so does that have to drive a change to our approach? And after thinking about it, we decided, again, very firmly, no, that actually privacy remains unchanged across these new technologies, and if you have the same fundamental approach, you can mitigate the risks, you can deliver great experiences. And so first and foremost to us was to turn to data minimization. And so, you know, when Brent talks about, for instance, these devices which might be mapping your surroundings, well, they don't have to be doing that. When we looked at, say, Apple Vision Pro for spatial computing, it processes that, and we built into the device the capability to do all of that locally and ephemerally. And so the interfaces that are getting rendered in a space are being done without exposing your surroundings to third-party applications or Apple. It's being done by the device itself. Certainly something we designed, but something that is designed to keep that user's data processed locally on the device, only used ephemerally, and not therefore collecting that kind of long-term machine never forgets sort of storage. It's a choice, and it's a choice you have to consider and bring into the design very early on, or you're going to find that your risks are difficult to mitigate later on if you haven't thought about them up front. So data minimization has been an important technique, even going back to voice assistants, where with Siri over the years, and with Siri 10 a few years ago, we've been able to move more and more of that processing of the domains of a voice assistant onto the device, so that it's the device that is listening to your audio and turning that into the words. It's the device that's doing reasoning about what that audio means or what the transcript that it generated means, to determine then if it's the sort of query that's going to require the internet and therefore need to connect off the device, or if you're saying set a timer for 10 minutes, that's something the device can just handle for you locally, and you don't need any of that information to be going off the device. So again, with spatial computing, we just said, well, we're going to need even more processing to be able to achieve that. Let's have the processing about the user's hands and gestures be done locally. Let's have that spatial awareness be done locally. And then if you need cases where additional access needs to be granted, then we can go turn to some of our other pillars, some of the other ways we look at privacy and say, well, that has to be clearly transparent. The user needs to be giving consent. But you move to that after you've done an analysis of how you can achieve data minimization primarily through local processing. And that just turns into very deep questions into the design and the approach of how you're looking at that platform and the capabilities it's going to need to provide to the user, that the platform itself has that support so that you can achieve data minimization. But there certainly are some novel threats. Certainly physical privacy comes into the space more in spatial computing, as Sylvia was saying. And for that, we started to consider that there is, I think, an increased awareness compared to the phone that we've been working on for so long. We were able, in the main, to assume that the user of the phone, that's the well-intentioned person. The device needs to be designed to protect its user from whatever threats we want to talk about. As we move more into devices that are collecting potentially ambient data or that are spatially aware, we also have to start to think about, well, what if that user actually is attempting to use the device in a malicious way to harm someone else's privacy? So we end up looking at it from both sides, that the user of the device themselves needs to be protected from harms in the environment or from others or from software. But we also now need to think about what about if that user is trying to take the technology and use it to harm others. And so for that, we took that big display on the front of Apple Vision Pro and we said, well, this is something that we can use to project outward. And this ended up having, even though it was initially a privacy conversation, it ends up actually feeding into the functionality, because our view is that users wearing this device should still be able to participate in the environment, to be less creepy to others, and also just from a usability perspective, that you don't want to have to take the thing off if someone walks into the room to talk to you. So that led us to have the display project outward so that people could tell primarily if that user was involved in an immersive experience or could be seeing them, even in an ephemeral way. And then if the user's taking an action on the device to do any sort of recording, that eyesight display indicates that out to everybody that's nearby. So they can just look over with a glance and see, is this device currently in a recording mode or not? And again, because it's default processing, even when you're running third-party applications, is that nothing about the surroundings is being exposed to that application. That means that we can rely on that assurance of the ephemeral processing of the device itself. We don't always have to be signaling that recording might be occurring, because when the device is in control of that data stream, it can give that representation that, no, this data is never being exposed, it's being forgotten, no recording is occurring. And that also helps with when you're talking about kind of the biomechanical data, not just that we designed a new form of the more traditional biometric authentication. It's optic ID, it's looking at your eye. That works just like Face ID does. It's something that is totally separated from the operating system, not exposed to it, not sent off the device. But yes, it is also tracking how your head is moving, how your hands are moving. And again, all of that, I would say it's not collected. The local processing where that data is expiring, there's a model that it's using. That model is protected so that it can understand where your gaze is. But if it isn't being retained, I don't think we look at that as collection. We see that as a form of protection. And I think gaze was one of the other real novel potential threats to users that we looked at, because yes, it's not science fiction at all to say that you could infer presumably a lot about a user, or at least try to make inferences about them based on where they're looking, based on where their eyes dwell. If we were doing the analysis now, are you looking at me right now? Maybe you're paying attention. If you're staring off into space, maybe you're not. People can try to get some signal out of this and potentially monetize that. And so we said one of the assurances that we have to build into the device from the outset is that where the user is looking is not being exposed to the application. Instead, it's when they make a gesture, which is a tap with your fingers to interact with the UI element, that's when the application should be aware of what you've done. And this is actually quite similar to how we all understand we interact with our laptops today, that if you're just looking at the screen, the laptop and the application doesn't know where you're looking, but it's when you make a gesture with a trackpad or a mouse that application becomes aware. It turned out that that was a real significant technical challenge, but we arrived at the same place where the user's natural understanding of when their information is being exposed versus not is something they can carry over from the laptop experience, and it works exactly the same way with Apple Vision Pro. And so what that meant is that if you want an application to be responsive to where you're looking, so you gaze at a button, and maybe that button gets a little bit brighter, that what we had to build into the platform was a notion of the application telling the device how I want, as the application, these different UI elements to respond to the user's gaze, having the device then apply that treatment to the UI element. And it's only, again, when the user taps that then the application is told, well, now that button has been interacted with. Maybe they were looking at it for 5 seconds. Maybe it was the third button they looked at. You don't know. What you know is that the user chose this button. They chose this element inside your application, and then you can go off and make the application take action based on that. Again, it's very natural. It almost doesn't require, or we don't think it should require a lot of thought from the user to have that view that this is how it should work. But it was only by really looking at that early on in the design to be able to keep that data minimization there with the kind of rich and immersive experience. So, in the end, I am fundamentally optimistic, but certainly there's a lot of work to be done. With that, I'll pass it back to Anna. Thank you.
Thank you very much. I don't know about you, I have plenty of questions, but maybe someone from the audience would like to go first. Yeah,
Hi, thank you everyone. So just wanted to share a little experience that I have on my research last year, and then ask you a question based on that. So I looked at the privacy policies of Meta's what was that, Pro headset, and it says we do not collect your eye tracking data or face tracking data, the raw data. We do not collect the raw data. But then there was something doubtful about that, so then we issued some fresh laptops reset our VR headsets and did an experiment where we are two people, and I played a role of very depressed person, so I won't look at her into her eyes, and she would try to say great things. And then one thing, that was planned, and one thing she said, I asked that something about Afro-American hairs, and she told me something. And then after 20 minutes, we finished the study, and we go to the Facebook page, our own pages. And what I see, the first 3 posts are motivational posts from Amazon, some books that are being sold to me. And the third one is a beauty salon, which is really close to my home. So now coming back to the question, if it is being sold in a certain way, that data is processed at the device, but the purpose of targeting content and advertisement can still happen. So how can we trust that, okay, raw data is not shared, but some inferences are shared, which still does the harms that raw data was doing 5 years ago? Yeah. And also, one last point, we looked at patents from Apple, Samsung, Microsoft, Google, and we noticed there is a trend on the gaze data, using the gaze data for targeted advertisement. We see that very clearly in the patents. And to me, maybe I'm wrong, but it looks like biometric data, which is used, maybe raw data or inference data, I really have no idea. But the problem still remains. Do you have to say something about that? Thanks.
Yeah. Okay. Yeah, thank you for your questions. So, I mean, just from Apple's perspective, first I would say none of that data is collected or used for advertising purposes. It's true for our voice assistant. None of it goes into anything related to advertising. It's true for Vision Pro and spatial computing as well. So just categorically, that's not occurring on our platforms. Certainly, when you say raw data is not collected, but maybe some derived or some inferences are, and then doesn't that still potentially lead to harms? I would completely agree. I don't think that trying to put up for users or from a privacy perspective a distinction of the raw data versus something where some value's already been derived from it and then that's transmitted. You have to look at what's being collected writ large. And so that's why when I talk at least about on-device local processing, I didn't specify as raw data or inferences, but I mean both. I mean that as a categorical statement, that if there's a risk that gaze data could be monetized in some way, if a user, we think that you can provide an experience without even having that be a possibility. Certainly if it was, I think a user needs to have an understanding and have consented, but it's much easier if you can have an experience where you get something that's responsive, which is what the developer and what the user is looking for, and just simply not have that gaze data or a derived form of it ever be leaving the device. So again, to me, it comes back to data minimization as the strongest protection I think we have in privacy to limit the amount of reasoning that you have to do about harms by saying just that data is not exposed in the first place in any form.
Would you like to?
Yep. Well, thank you for the question. That's a really interesting study that you ran. I think it speaks to the importance between, are we talking about raw data, or let's just say observed data, data provided by the user intentionally to a data controller, to a company, whoever, versus data that is created by a third party. So that can be inferences. But basically, as soon as a third party gets involved, so as soon as the data controller puts some effort into creating the data, suddenly the balance shifts. Suddenly, it's not just the data of the user, or at least they're not the only ones that have an interest in how it's protected, how it's used, how it's transferred. Suddenly, that data is also commercially valuable, and that commercial value is recognized as a sort of valid interest within data protection law, at least. So you may get into this weird sort of situation where if you tried to, say, request access to your data from a platform, you wanted to rectify it, you wanted to delete it, data that you have provided directly, you would probably be able to do all of those things with it. If it is data that has been inferred about you or created by the platform about you, there's a very good chance you won't be able to do any of those things, or at least be able to do them in a very limited way. There was a case with Max Schrems requested data from Facebook. I think it was in 2014 or so, maybe slightly earlier than that, where essentially exactly that distinction ended up being really important. He was given all of the data that he had provided to Facebook, but anything that they created about him, like the audiences that he belonged to, his inferred interest, he wasn't given that on the basis of trade secrets and intellectual property. And so keeping the raw data on the device, doing that sort of on-device processing, I think is a really, really important thing in terms of privacy by design. But it's just as important to ask, but are you inferring something about me? Are you passing those inferences on either to yourself or to third parties, to apps, whoever it may be? Because that is ultimately the most interesting thing, the most marketable thing, and the thing where, you know, you immediately have other legal interest involved, but maybe even more fundamentally, if that is de-identified before it goes anywhere, as soon as it gets de-identified, you more or less lose your rights over it anyway. And so we have to be asking questions like what you asked, both about the inferred data, but also about data that ends up de-identified and then still being used for other purposes.
Thank you for the question. And one thing that I think very often also in this conference and in academic settings we end up bumping against is that ultimately the predatory business model is still the most convenient for a lot of companies. It is the most convenient for a series of also social reasons, like cultural reasons, one of which is that we do believe that the democratization of technology, which is a wonderful thing, actually should come at a very low cost, and then we choose then to ignore what that means, and we've ignored that for decades. But there is an inherently predatory nature in a type of advertising that's done online, because it took the normal approach of advertising and marketing that was always there, which was let's find the vulnerability. It's there. Everyone has watched Mad Men, I guess, right? So we know that's what it was. But starting roughly from around 2005 or 2009, so then at the end of the short decade that came after in the early 2000s, that went on steroids. And we're still paying the consequences of that. So the legislator has been trying to change that incentive with not just the rules, but the penalties. Because that's what we need to do. We need to find a way to make the predatory business model of a lot of apps, of a lot of platforms, of a lot of devices less appealing. Because otherwise we're going to keep going back to this question. And we all know, the legislator knows, most developers at this point I think know, but that's where we keep bumping. And I really liked your question because it also offers the occasion to reflect a bit more in depth on two things. And one is the vulnerability of some people. Spatial computing, augmented reality, virtual reality can be wonderful for people with neurodivergencies, can be wonderful for people with disabilities. Same with Internet of Things and wearables. But these folks then are more vulnerable because it creates dependencies. If their life gets better, they are more prone to being exploited because the threshold for abandoning these devices and these technologies is higher for them, and that's extremely unfair at that point. So that's also where, for example, I see a bigger public role where maybe we need to collaborate, we need to have more collaborations within public and privates where we say, okay, then let's develop certain technologies for assisted living facilities. Let's develop certain technologies where we make sure that we add extra protections because we really want to enable these people. And if I may add one last thing, is that is something that I also find very interesting, is that these technologies are going to mediate how we interact with reality, and philosophers can explain that better than me. I don't want to take their place. But they're going to mediate how we interact with reality, and the result of that is that they can mediate the values that we're going to ascribe to reality, and that can result in us being steered persuaded, manipulated. Like imagine, virtual reality dark patterns have already started being investigated. And I myself have looked at voice interface dark patterns. So these are also new chances where that predatory business model comes back into, finding an opening into actually also manipulate a bit and remove a little bit of the autonomy and choice. And it's going to be very exciting for us researchers, I guess, but we need to keep an eye on that too.
Thank you. Many things that we could delve into in more detail, and I hope we still can. But I believe there was another question further at the back. Do you still want to? Sorry. Excuse me, do you still want to ask the question?
Hi, my name is Alia Polera. I work for Morrison & Foerster. I have a question actually for you, Eric. I applaud on-device processing. I think this is something that all companies need to consider right now because this is the future. But the question is actually the other way. How much of the access do you still have on the data on the device? And I assume there's not much access, but how do you ensure that no access happens even if it is potentially possible? Thank you.
Thank you for the question. And I think it's good. I can see that simple statements in this room get challenged, and I think it's good challenges. So, no. I mean it in the sense of I left something unsaid, right? Which is to say, if there's on-device processing and on-device data, you're saying if there's access to that, then what was accomplished, which is a very, very fair question. And so, no, there's not access. I think it is a subtle distinction that we see very clearly internally, but because of how Apple has structured its approach, comes across subtly to everyone else, which is, yes, we built the hardware, we designed that maniacally, yes. We also build the software that runs on that device, and those are things that we as a company do. I'm employed by the company, I work on building that software. Once you then purchase that device that is running the software we wrote on the hardware that we made, that is very much yours. We don't have a capability to reach into that device and pull something out of it. We haven't designed it that way. And the software that we publish that people who are very technically skilled can investigate, would confirm that we don't have that ability to say to a device remotely, you must now upload everything to us. So there are different levels of protection that we look at when we talk about things like the biometrics for authentication. That's actually totally stored outside of the operating system, so it in effect has an even greater level of security around it. But even just for the data that you have stored natively on the device, some third-party application data that's stored there or something from one of Apple's applications that's stored on the device, that isn't something that we have given ourselves the capability to pull from the device, nor is it a capability that I would be supportive of.
Where is the mic?
Hello, my name is Larea Mendeguren. I work with NOIB, the European Center for Digital Rights, and in the spirit of pushing back against simple statements, some might say, I'd like to push back against Brent's statement about inferred data and just ask you a little more about that. I don't think it's clear that inferred data doesn't merit the same protections for individuals insofar as it is personal data that is identifiable and linkable. There are protections that I think that would extend to, and that's also included in the US under the California Privacy Rights Act. Inferred data is explicitly included as a form of personal data. So I'm hoping to get a little bit more from you on why you think protections might not extend to that in the same way, and the rest of the panel's thoughts to the extent that they have some.
Thank you for the question, and I love your organization. So just to clarify one thing, my comments were about specifically the GDPR, so not applying to the California Act at all. The reason I would say that is because of the existence of other interests rather than just the individual data subject's interests that can mean that you're not able to exercise your rights, specifically the right to rectification, the right to erasure, in the same way that you would be able to if it was just personal data that was only about you or where it was provided by you directly. What I mean by that, there's been some case law from the European Court of Justice that was looking at, for example, somebody trying to get access to comments from an examination. They were essentially trying to get access to the examiner's comments on their exam script. They could have also potentially asked to rectify them, so if they disagreed with their mark, disagreed with the comment from the examiner, because that is personal data about them. It's data that is used to assess them as a candidate. They, in theory, could have exercised their right to rectification, changed the comments, changed the mark on the exam. In that case, it was recognized that the data, the comments in question, were both the personal data of the exam candidate, but also of the examiner. And so the exam candidate did not have, at least through data protection law alone, the ability to rectify those comments. The decision around that was sort of deferred to what they called the competent authority in that case, so the exam board. Basically, it was recognized that data protection law is not there to question decision-making procedures or to ensure that they are correct or to give you sort of full access to them. They recognize that basically those responsibilities rely with other competent authorities. So it's mainly those cases where you have the interests or the rights of the individual data subject running up against the interests either of somebody else whose personal data it also is, or who had a role to play in creating the data. So the example I gave of, say, if Facebook creates audience data about you and they have put time and resources and computational resources into actually creating that data, whether you would be able to rectify it, for example, if they categorized you as depressed, whether you would be able to have that deleted if they argued that it was commercially sensitive data or commercially valuable data. As far as I know from the case law, that is still sort of a contested thing that you'd be able to exercise your rights in that way.
Thank you. If I could add a footnote to this, I believe that I understand this the same way. I think the courts have not really clearly decided yet, even though I should stress that the majority of data protection authorities hold the view in other contexts, and notably online behavioral advertising, etc., that inferred data in many cases, if not all cases, would also qualify as personal data. But indeed, this is the view of the EDPB, of the individual DPAs, but the Court of Justice has not necessarily clarified that entirely yet.
Can I add to that one thing, that there's also the Uber case where not all the information about the ranking and the rating of the drivers was actually given because of know-how and trade secrets. So there's definitely a tension where obviously the definition is rather clear in this sense, meaning that the moment it relates to an identified or identifiable human being, it's going to be personal data, but there is resistance because of the more IP-related aspects of it.
And sorry, just one other thing to clarify. I didn't mean to suggest that inferences are not personal data. That was definitely a question. Again, in another case I'm thinking of that dealt with immigration case, or no, an asylum case. Rather than sort of adopting the three-step model where, you know, basically if data is about a person or is used to assess a person, it would be considered personal data. In that case, the court said it's just facts about a person. And so you can question whether inferred data would actually be facts about a person. But as far as I know, the cases that have been heard since then and the interpretation by data protection authorities have very much correctly, I think, gone in the direction that, yes, inferences will be personal data.
Shura, please.
Does it work? Yeah, sorry. Shura Nas. I have a short follow-up question for Eric from Apple. So I always use the example of the telemetry data sent from the iPhone as an example that no, Apple doesn't need to get direct access to the content data on my iPhone, but it has programmed the device to send lots of very detailed information about my behavior, my use of any application I've installed on my iPhone continuously back to the mothership, and it sends my location very high frequently back to the mothership. So maybe you don't need to access the content, but I wonder I have looked at the Quest Pro telemetry data, very interesting. I haven't yet had the pleasure of looking at the telemetry from the Vision Pro, but have you applied the same technology in the Vision Pro to send the telemetry data back home about the use of the device?
Yeah, thanks. So I think the program you're referring to, we call the Device Analytics Program, which first and foremost is an opt-in program. And so users that opt in to provide telemetry or analytics about the device, that does come back. That data is visible on the device. You can get a list of the files. One thing that is also true is you can see that list of the files even if you didn't opt in. You don't have to opt in to send it to Apple just to see what the data would be. So you see that data regardless of whether or not you've opted in. If you've opted into that program, only then is that data sent back. It doesn't include, it can include in the case of some cellular cases, there's information associated with location. None of that is related back to your identity or your account. We're at great pains and we actually analyze each request from a team to put data into that data analytics program because Apple's not in a position, and you can see this in the transparency reports that we publish, we're not in a position to know where any of our users are. So insofar as there's any location equivalent data that's in those diagnostic logs, it's separated and reduced from any sort of thing that could lead back to an identity, and we're very keen to keep it that way. So it is data that you can inspect. It's transparent there on the device, but it's not associated with your identity and will only be sent back if you chose to opt into that program. Oh, and for the Vision Pro, when you say the same technologies, we've taken that same approach. We think transparency is important, we think consent is important, and we're applying the same practices with the telemetry there, that it won't be related back to your identity. And when I talk about not sending back the, you said biomechanical, is that your term, Brent? Yeah, biomechanical data or things of that nature, when I talk about the on-device processing there, it's not being sent back as part of the telemetry either.
Thank you. Maybe just, I will abuse my privilege as a moderator to also ask a question. What struck me in these discussions is that we are essentially looking at many challenges that have existed previously with other technologies. The difference might be that they are getting combined in one single device. And probably the use of AI, even though I haven't heard that mentioned too often. So my question is your view that the currently applicable legal frameworks, such as the GDPR, maybe other rules, are sufficient, are enough to tackle those, to address properly those challenges? Or do we need something more, precisely because, as you said, these might be old challenges, old problems, but on steroids in those new devices. Do we need something more, better, newer that would be necessary to tackle any of those challenges that you have discussed?
For the legal scholar, I think I speak for quite a bit of my colleagues too when I say please take a break from new laws for a bit because we're lagging behind and we need a little bit of time to really delve into them. But besides that, no, I don't think that this is just a new iteration of the problems that we've been discussing for the past years or decades. I do think there are also some challenges that are emerging that are becoming a bit more specific for these new technologies. And one, for example, connecting to this last question, I'll give you a little spoiler of what I am writing now, so let's keep it private between us and the video. But I think that at this point, especially with Internet of Things and augmented and virtual reality, we can mostly assume that we are blurring metadata and content data. And actually, what's lagging behind here, in my opinion, is the case law, meaning that the Court of Justice is operating often with assumptions that are at best from 10 years ago about metadata, and they're simply saying, oh, now there is more metadata. It's not just, it's the type of metadata that we have from these devices that is actually really comparable to content data at this point. the raw data, inferred data is starting to blur a lot into the moment we have the granularity from the different devices and the permeability, the fact that they're present for longer times in and around our private sphere, that means that it's very blurry. And so this is going to be a new challenge a bit because it's going to be an interpretative challenge. So I think the framework, the problem and the advantage of our framework is that it's vague, and the law has always operated creating sometimes the empty boxes, I call them, the empty box provisions, and then we need to fill them in based on our actual and concrete necessities. And that's the challenge now, is moving from the correct assumptions on how this technology works and how the business relationships among these companies and many actors work for the correct interpretation to fill in the empty box provision, if we will.
Would you like to add?
Yeah, I'll just quickly say, so I don't think there's any appetite to create a new GDPR just yet. So I think it does have to be a question of enforcement, case law. So I totally agree on that. I think we need to go back and remember what the original purpose of data protection law was. That was about protecting people. We need to, so much of it focuses both on individuals and on the input side of data, basically how data is collected, but very little on the output side of data, so what you are allowed to do with it as a data controller once you actually have that data. So I'd like to see some, basically us revisit that and in particular start to challenge the processing that is being done, the inferences that are being drawn. Ask up front for justifiability, ask up front for information about why your method is reliable, why you think it's reliable, what you're going to use those inferences for. I'd like to see those things actually addressed before the data is ever processed in such a way where you would draw the inferences, because then I think you can sort of round out data protection law so it's not just about the input side, that it's also about the output side. So hopefully we see some of that through enforcement of it. I think we are seeing more protection or more, at least interest in inferences in recent years, so hopefully we continue down that path.
So what I'm hearing is the principles which underpin privacy laws, data protection laws, remain valid. The challenge will be how to apply them effectively to address some of the new degrees of harms or risks that appear here. And maybe in particular data minimization. From our perspective, I would probably also mention data protection by design, by default. It seems similar to that. But no appetite or no pressing need for new regulations.
Well, I am a U.S. citizen, so notwithstanding Sylvia's point, I would say some strong federal privacy legislation in the U.S., a little bit more privacy is a fundamental human right. I think that could be okay.
Thank you. There was another question.
Yes, thank you so much for the panel. Thinking of the new challenges, I wonder what is your opinion on avatar data? Because when the person is impersonated in the avatar, they will not necessarily behave in the same way that they behave in the physical space. So think of violent games, for example, and all the biometric health data that can be collected there from the person. So I was wondering if you have any opinion on like a possible separation between the data that is collected when the person is impersonated in an avatar and the data collected elsewhere, if this should exist, if it makes sense. Yeah. Thank you.
So I haven't thought about that in great detail. It reminds me a bit of the idea we had around robotic personhood as a way to deal with some sort of legal gaps. So I wouldn't want to see something like avatar personhood. I do think, though, that there does need to be specific attention paid to avatars, especially when it relates to, it's weird to say physical privacy in a virtual space, but that's essentially what it is. The research that I had on the slide around harassment was looking at exactly that. It wasn't just about people being harassed by voice, but it was actually about their avatars, or them being harassed through their avatars by other people encroaching on their personal space, making gestures at them, just basically making it a very, very bad place to be in whatever virtual space that they were in. So in a way, you might need protections that are focusing specifically on the avatars when it comes to how other people interact with them. But I would hold back any opinion yet on whether we need to consider them separately when it comes to like data protection issues.
Thank you.
Can I add something to that? Sorry. I think we need to separate the two things. So the behaviors, I totally agree, 100%. But if data from it's still user data and it's still personal data the moment in which it's relating to an identified or identifiable person. The fact that they might act differently because it's behind an avatar, whatever, it's their choice. And it's going to be treated as personal data. So my point is, let's simplify things. Let's not conflate and let's simplify things. So, if I am playing D&D, I'm acting as my character, but it doesn't matter. It's what I am doing in the game, video game or tabletop game, doesn't matter. If we want to protect the personal data, then we use the rules that we have, which are if it relates to an identifier or identifiable person. The fact that we might alter our behaviors and that then might go into the profile, that's simply a matter of what the use of the purpose and the use of that profile will be. And again, we just rechannel everything into the existing thing and we simplify the problem based on the existing rules, I would say.
Thank you. I think we had 2 more questions here on the...
Okay, thank you so much. We are talking a lot about the perspective from the user, and I would like to know, like a lot of the devices now are recording in the street, even not being a user. Do we have any rights as a non-user of these technologies, like the Ray-Ban glasses or like the Apple glasses if you are going in the street? Thank you.
I mean, yes, it's, as I said, privacy applies. Privacy of bystanders in public applies. The legislation accommodates up to a certain level the expectations of privacy in public places and private places even more so. I think it's also important to start talking about outside of the law, about a new etiquette. So having studied a lot smart speakers and Internet of Things at home, I always recommend people to clearly inform their guests and the people working in their house, like cleaning personnel or babysitters. Yes, we have this device. Do you want me to turn it off? This is how, this is where it is. So the etiquette is going to be very important. I really appreciate the protections against malicious use because I have little trust in some very ruthless influencers going in public, pranking people, etc. But we do have the rights, and we need to start also talking about it even outside of the law. The law is not the solution necessarily to everything. The lawyer is saying that, ouch. But it's true. Let's start becoming a bit more, let's start putting back also solidarity and community in developing a set of etiquettes and demanding this from people when we're visiting them. And let's look also at, Airbnbs and all these gray areas in that sense. But you are protected and we are protected and we need to just be very firm about it at this point.
Yeah, I think that's right. I mean, if privacy is a fundamental human right, it's a right for all humans, not users, non-users. That's not a distinction that makes any sense. I think that etiquette comes into it a lot, and from a device or a design perspective, we need to make it easy for people to behave correctly with good etiquette. We need to put protections so that if someone's trying to undermine that and try to harm somebody else, that we make that more challenging.
Thank you. There was one more question here.
Okay, last but not least, hi, my name is Burcu Kılıç and I work for CG. So I have a very quick question about spatial mapping. And how important is it for immersive experiences? Because, I mean, we need to give credit when the credit is due. So thank you, Apple, for, locally storing and processing the eye tracking data. But when it comes to spatial mapping, there's a challenge there, because the challenge is if you're investing $3,500 into a device, you want an immersive experience. And then when the device asks you, like, do you consent to share your spatial mapping, you say yes. So the challenge is, yes, like the developers, and they say that they need the spatial mapping data, spatial data for creating immersive experiences. Developers need that data, and then they ask you, and the users will consent. So the challenge is, like, we put the burden, the responsibility on users, but users, they want immersive experiences.
Yeah, thank you for the question. I think, first of all, there's a wide array of experiences on Apple Vision Pro, and I think we're in the early days. So I enjoy many things that do still have that spatial immersion in the sense of being integrated into my surroundings. And again, as I've said, that's without actually needing to be asked that question, needing to grant that position. I think what you've seen across our platforms over time is that we're going to have successful products and successful experiences for users where we make things easy for developers, which means building capabilities into the platform that developers can use. I mean, when I've been going on and on about on-device processing of data, that's not, I mean, something we care about certainly very much inside the company and for what we design, but we design the platform to enable developers to use this same power, to get the AI name check-in that Anna was saying we haven't done enough of. We have the neural engine silicon in our device, which helps deliver AI inference locally. That's available to third parties. And so I think that we're going to continue to build out the platform where people can have whatever experience they want, and with data minimization as one of our primary guiding lights, as you'd have it, we're going to provide developers more and more ways that they don't have to ask that question. And then when they don't have to ask that question, the user can engage with that developer's experience in a more trusting way.
Thank you. We are almost at time, but I still would like to ask one last question to all of you. I think here we've been thinking mainly about the wearable VR headsets in particular, some of which have been on the market for quite some time, others are new. But my question to you is, what is next in the field of spatial computing? What should we worry about, or what should we look forward to in the next months, years, and foreseeable future?
Sylvie's suggesting I'm the most qualified. I'm also probably the most constrained. I would say watch this space. I don't know, I think what really, if I think back to when we introduced iPhone in 2007, I don't think anybody could have predicted the kinds of apps and the kinds of experiences people created. Even though I know some devices have been around for longer than ours has been, I think we're in the early days of what people will be able to do with spatial computing, and I'm really excited.
So I hate people that try to make very accurate predictions, and I know that I will probably regret saying this. But if I look at some of the trends from the past few years that have been ebbing and flowing, so kind of coming and going in waves, I think that there is still the tendency to try and make the interface as frictionless as possible, as invisible as possible, and as embedded in the environment. So I think probably I can't say if it's doable. I'm not a technical person. I can't say how long, but I think that the tendency would be to look at basically a more invisible interface, user interface, and maybe incorporating the spatial computing in the environment itself, which is easier in smaller places, clearly not in public. But that, I think, would be quite a bit of a long-term thing, which will bring, if it happens, its own challenges.
Yeah, and I will use the same caveat. This prediction, let's say, I'll stand by it for 12 months. After that, it's off the table. Yeah, the interface becoming less visible, I think, is definitely something we're seeing. There's been a couple devices, I can't remember the name of them right now, that were essentially like badges that you would wear that claim to have AI on them, and they can act as like an assistant. Maybe we'll see something in that direction. I think maybe the broader trend, though, would be more integration of large language model powered AI agents or AI assistants into any sort of spatial computing devices. I think you'll see that across the board, but definitely within spatial computing.
Thank you very much for being so brave and offering some predictions. And thank you. You have been a fantastic audience. Please join me in thanking also our panelists for this excellent discussion. Thank you.